SJC-13083, Keith Haring, v. Commonwealth.
Okay, Attorney Sharukum.
Thank you. May it please the court, my name is Aviva Jerusalem, and I represent the appellant Keith Haring. The court should reverse the order of the single justice for 3 reasons. There were no novel, systemic, or case-determinative issues presented that merited a substantive review of the merits of the petition. Per Fontanez, the single justice should have denied this petition out of the gate. Second, the abuse of discretion standard should have been applied instead of de novo, where a lengthy record had been developed by the court below that carefully considered and balanced competing interests in a bail decision. Otherwise, loosening those standards will open the floodgates of requests for de novo review in the single justice. Third, if a triable case, stringent conditions of release, and a plain risk of death are not enough to create a rebuttable presumption for release in a first-degree murder case, as envisioned by Vasquez, then what is?
Ms. Jerusalem, good morning.
Good morning, Your Honor.
I was wondering who Vivian was. But anyway, so let me ask you about issue number 2 in a procedural question.
Yes.
Did the single justice have a right to have an evidentiary hearing? So the first decision the single justice has to make is, do I decide it on the papers, or do I have an evidentiary hearing? Did he have the authority, and you have no issue with him having an evidentiary hearing?
That's an excellent question, Your Honor. Certainly, if the court accepts, and it should, that a petitioner can has a right to a de novo hearing, then arguably, certainly, in a de novo hearing, then witnesses could be considered in a hearing. The appellant's position is that in this case, and
you hit the nail right on the head, and that's the meat of my question is, as you anticipate. So once the judge had a hearing, I can't see how the judge can then say it's an abuse of discretion, because the judge is hearing new facts, and then it becomes a de novo. So are you saying it was error for the judge out of the gate to say, I'm going to have a hearing?
yes, it's exactly what
All right.
I'm saying.
Where are you getting this?
Well,
And I don't see that in Comesco, but where are you getting this?
so frankly, there isn't any firm case law one way or the other, which is why I think the single justice considered the issue de novo.
So I'm sitting as a single justice. We get bail reviews all the time. And I say, geez, this one's complicated because government's saying that they didn't have a right, they didn't get the final word, and they didn't have an evidentiary hearing. The judge kind of did something, some backfill in here. I'm going to have a hearing to see what's what, and hear these witnesses for myself. If I decide to have that hearing, you're telling me that's error.
Well, I would suggest to the court that it is error in a case where there has been a very lengthy and developed record below. The court has 2 choices as it exists today. The court can consider an abuse of discretion standard, or the court can consider a de novo standard.
So we say the Superior Court judge did a wonderful job. We can't touch it, basically.
Well, and again, I would suggest if the court reviewed the amicus brief, and I think that the amicus got it right in this particular instance, that when it comes to a bail decision, and the presumption is for release, the presumption is not to be held with bail, I would suggest that the case law, Comesco, everything that follows the bail statute, doesn't support a do-over, if you will, by the Commonwealth. And that's exactly what happened in this instance, where there was a very lengthy record from below.
And let me ask you, you've answered my first question, but my question, but let me ask you about your issue number 1, and that is, why are we here? Is it your position that bail reviews by the Commonwealth do not merit 211.3 review?
They don't merit, no. Well, I would, if the court will go that far, then on,
But what's the standard? Because we look for extraordinary, so what standard should we look to see whether or not something's extraordinary for 211.3 when it's a government appeal?
right, that's exactly right. What is extraordinary for the government of the Commonwealth about a bail petition? Certainly, if we consider our constitutional history of presumption of bail, presumption of release, then there's nothing that would militate towards the
Okay,
Commonwealth.
let's stop with that answer for a minute. Excuse me, Justice Gaziano.
I'm done.
But Commonwealth versus Baker, I don't think it's cited for sure in your materials. It's from 1961, and it goes deeply into the bail history in Massachusetts. And it points out that there was no bail in the older cases for capital crimes, and now we know that murder is a capital crime. So the presumption actually goes back very far in our history, not the presumption, but the fact that it is a discretionary issue. People are not entitled to bail. There's no right to bail on a first-degree murder case. It's a discretionary call, and that's ancient history here.
Yes, it is. However, of course, the legislators had the opportunity to rewrite the bail statute and to say there is no presumption for bail.
They haven't done that with regard to first-degree murder.
No, it hasn't been done. So again, and that's why this esteemed court in Vasquez said, yes, we can consider circumstances for a release. And that's exactly right. And so if the court has the opportunity to consider circumstances of release, then essentially it should have, in this case, it did. And then essentially, as I use that word do-over, the Commonwealth essentially got a do-over.
Well, but
to
let's go
reconsider
back
it.
to that for a minute. Why, if it's a discretionary issue, it's not something the defendant has a right to, why is the Commonwealth precluded from using the 211.3 avenue to seek what it sees as an error?
And that's a great question, and I'll turn it around. We have set standards, the court has set standards for what merits consideration in the county court, which is essentially it's case determinative. A bail review is not case determinative. It's a novel issue. This isn't a novel issue. There's nothing here that it's not systemic. None of those issues.
I'm confused. I thought we had some case law that says that the Commonwealth does have a right to a single justice review of bail. And you have a great point about what's extraordinary and what's not. And we're going to ask the Commonwealth where the line is. But we do have case law that says the Commonwealth has a right to a single justice review in bail, correct?
Yeah, the single justice in its discretion has the right to review anything, bail, otherwise. That's not the case. The case here is, number one, we have a standard for review for the single justice. Does that standard become denuded?
Is it ever extraordinary, in your opinion, on a bail decision? Because
No.
you got into, whether it's substantive, whether you lose all the evidence, et cetera. Your opinion is, no, can't be.
No, I would, if the court would adopt that rule, I would suggest no, it shouldn't be. Because if it is, then essentially every time a litigant, whether it's the defendant or the Commonwealth, is aggrieved by a lower court's decision, then it has the chance to reconsider that decision. And especially in this case.
Do the charges, in this case, the murder charges make it extraordinary?
No, it doesn't make it extraordinary. And I will point out why. So today, yes, it's a life felony, and so first-degree murder would be considered one of the most serious, if not the most serious of crimes. However, as a practical matter, today, we have so many enhanced sentencing ramifications, whether it's armed career criminal level 3 or habitual offender, that essentially we have the practical effect of creating a life sentence for a defendant in any circumstance. So whether it's life without parole or a habitual offender on a life felony, which could be effectively life parole, life without, basically a life without parole sentence, or a sentence that essentially renders a defendant incarcerated for his or her natural life, it's the same practical matter. And so I would suggest that in this case, otherwise, why every litigant would come into the county court, the single justice session, and expect a new hearing, and would have a right to.
That was your issue number one. You've talked about issue number two. Let me get to your issue number three, the merits of the decision.
Certainly.
The judge had a hearing. He considered all the evidence, and he made findings and balanced it. How is it an abuse of discretion for him to look at the risk to the defendant and the COVID risk and determine that he shouldn't be bailed?
So the problem with the hearing as it took place with the single justice is essentially it excised a lengthy history of abuses by the Department of Corrections, which the trial judge, in this case an experienced judge, considered, and not lightly. The trial judge in this particular case actually weighed in favor for the majority of the time in favor of the Commonwealth. But at a certain point, hearing over and over again.
You get an adverse decision, and all of a sudden the single judge is excising all the good stuff for you and abusing the discretion because they don't agree with the. You see how that sounds? That the single justice is supposed to defer, in your view, to the lower court judge?
Well, we have an abuse of discretion standard.
Well, again, we're back to de novo. This judge decided to have a hearing because you can presume he didn't like the record below, given that the motion judge below, at the very end, just decided after, based upon submissions, one-sided submissions. So the single justice decides to have a hearing. But your view is that's all error because he should have just deferred to what the motion judge did?
In this particular case, yes. So typically with bail reviews, as the court is well aware, it's a fairly brief process. There'll be perhaps a district court judge will hear the issue of bail.
That's exactly my point.
Right.
It's a fairly brief process, usually with the single justice too, right? So,
Right.
and I don't think I've had a hearing on a bail review. I've decided them on the papers, but this judge took the extraordinary effort to have an evidentiary hearing. That's what I don't get. Where your argument, where he somehow commits legal error when he decides to turn over the rocks and see it for himself what's going on.
But the single justice, the county court has available to itself the abuse of discretion standard. And when you have a record from below that is as well developed, unusually, I would say, as it is in this case, I would suggest to the court that it was error for the single justice to essentially, as the court put it, turn over the rock and say, I don't like that decision. Let me come up with a new one. Well,
That makes it sound so casual.
No, of course not. I'm merely, I'm just repeating the court's words, and I think that they were appropriate. That's exactly what took place here. No disrespect whatsoever, but when you have weeks, months of a history in a particular case, especially in this case, where the lower court took pains to consider and reconsider not only the defendant's motions for reconsideration, but the Commonwealth's motions for reconsideration. The judge in the lower court didn't come to the decision lightly, not by any means. In fact, the judge in the lower court took an affidavit from one of the witnesses who ultimately testified at the single justice
Counsel, how
hearing.
many motions to reconsider, in your estimation, would require the single justice to use the abuse of discretion standard as opposed to having a de novo?
That's a great question, and I don't have an answer for that.
Well, I mean, you're asking us to decide that this particular single justice abused discretion by choosing to have the de novo hearing, and you're pointing to the number of motions for reconsideration. I'm wondering, as a legal proposition, when does a single justice bound by that?
In this particular instance, and I know the court obviously has all the pleadings and the record appendix.
So
but
3 times?
I would say that if there's a reconsideration 3 times, then that would have indicated to a single justice that the record had been amply
And what
reviewed.
is your legal authority for the 3-time limit?
There's no legal authority, which is why when you asked me that question, I don't think it is the number of times that the court considered or reconsidered the issue. I think that it's the depth of consideration, it's the quality of consideration that probably should move the needle towards an abuse of discretion rather than a de novo standard. In this particular case, the court had considered or reconsidered at least 3 times the issue. But not only did it reconsider the issue, it had considered affidavits, it had considered 2 live witnesses, including the defendant and the special sheriff of Middlesex County. It had a substantive record from below. And in that particular case, in this particular case, if nothing else, the single justice should have never touched this out of the gate. And there was no reason for the single justice to do so. And I would suggest that it was an abuse of discretion for the single justice to even consider the merits for all of the reasons that I've described.
Okay, thank you very much. Attorney Charles.
Thank you.
Thank you, Madam Chief Justice. May it please the Court, Assistant District Attorney Jamie Michael Charles for Middlesex on behalf of the Commonwealth. My sister just referred to the depth and quality, or the purported depth and quality, of the lower court judge's decision-making in this case. But the reason the Commonwealth went to the single justice in the first instance here is because approximately 24 hours after the defendant filed a completely self-serving motion, not even supported by his own self-serving affidavit when he initially filed it, an affidavit that was filed after business hours the night before the judge made the decision, this judge, without giving the Commonwealth an opportunity to reasonably respond, without holding a hearing as CPCS envisions for these sorts of motions, allowed a murder defendant who committed that murder while out on GPS for another attempted murder kidnapping indictment to be released from custody.
Mr. Charles, that sort of begs a very important question. You're laying out that perhaps there was an error of law or abuse of discretion. And we need to talk about that. But there's an initial issue to be addressed that wasn't addressed by the defendant. It is addressed in the amicus, and it's important. In Camiso versus the Commonwealth, and in a footnote in Vasquez, we leave open in Vasquez and don't address in Camiso whether or not a defendant should have to face another de novo review when a petition is denied, meaning they're going to have to win twice before 2 different judges. Why is it that where a judge, or maybe 2 judges, maybe the district court judge and then a bail review in Superior Court, the Superior Court judge, they deny, they allow bail, there's an allowed bail. Why should the judge then, sitting as a single justice, review that again de novo? You got to win 3 times as opposed to as an abuse of discretion. And a comiso where it's the defendant who lost and has come in the single justice. In Vasquez, the defendant loses, comes to the single justice. But when the defendant wins, why do they have to win again or even win twice or 3 times?
Well, a couple things. First, again, there was no district court evaluation in this case. We're
I
talking about a
understand.
Superior
It's
Court
Judge
judge's
Wilkins on it.
And I also want to make clear that we do think, and we did argue, that this was an abuse of discretion, given the manner it was
I know, and
procedurally
I know
handled.
you're not done with it, and I have questions about that, but this is an important issue.
Correct.
Amicus brings up the issue, and we've left it open.
So, first of all, my sister and Amici cite Fontanez, but they only cite, they keep citing this, I believe the language is novel, systemic, or case determinative. But if you read this for the rest of the sentence, I think essentially it says, or under extraordinary circumstances.
Assume it's extraordinary circumstances. You're there. So you argue abuse of discretion or error of law. Assume that it's extraordinary circumstances. Assume that you absolutely fit within Fontanez. If the bail was allowed, why is the single justice reviewing it de novo as opposed to for an error of law? Maybe the judge should have the option of doing both, but we've never squarely addressed that issue.
I would certainly agree that all of the cases that have spoken of the authority to consider it de novo have done so in the context of defendants appealing.
Right.
I don't think the fact that you've only weighed that issue doesn't mean that it suggests the contrary for purposes of what is permissible.
Sure, maybe.
I would
Give me
also
the why.
note-
Give me the why.
So for a couple of reasons. First, I don't think we need to get global in this case. We're talking about a murder defendant who does not have a right to bail, who is not within the realm of everyone else in the criminal justice system who is charged with a crime. We have a decision of the lower court that really didn't give an, as to the motion that the Commonwealth appealed up, not the whole record, not motions that considered the defendant when he was still held at a different detention facility, which is for all intents and purposes irrelevant for the present purposes, that there was no record underlying the decision below. There was a motion filed by the defendant making self-serving representation
But I don't
and a
know the
ruling without a
answer to your
hearing.
question. I don't know the answer to your point, but I understand your point, that it was an abuse of discretion or an error of law. And I respect that, and we need to talk about it. But my question is way before that, because this was de novo. It's an open issue.
So I guess I would analogize to, and I know it's not a clean analogy because there are rules that deal with it, but in the stay context, for example. In the stay context, the Commonwealth is permitted to appeal to the single justice under de novo review, and that's the closest scenario, recognizing that there are differences that the Commonwealth can recognize. I believe my sister and Amici cite to Hodge in their submissions for the suggestion that when there's a reasoned judgment below, you shouldn't be allowed to get de novo review before the single justice. And I would just point out that in the Hodge case, I think the court said that the trial judge in that case was making his stay decision, I quote, on the basis of first-hand and complete information concerning the conduct of the trial. And the Commonwealth's allegation here, again, I realize I keep coming back to it, is there wasn't a complete record and information before the lower court judge. So this judge was faced with a situation where he needed to create that record. And I don't think there's any case law that says he can't. I think there's ample evidence in other contexts, for example, in bar disciplinary proceedings. The Commonwealth found a case where the single justice took evidence on a request for injunctive or declaratory relief in an election dispute. That's 362 Mass 708. Matter of McInerney, I apologize if I'm badgering that, in the attorney disciplinary context, 389 Mass 508. So there's clearly a track record of single justices being able to take evidence. There's no case law that says that they can't consider the matter de novo. We're talking about somebody who is not presumed eligible for bail because he's charged with a capital offense. And we have a record below that was insufficient on the present motion. Again, I'm not saying there wasn't adequate evidence taken in other instances previously. But the last, and I think this is important to note, the last motion that this judge heard before the defendant's seventh motion for release, was the Commonwealth's motion for reconsideration of his January motion allowing the defendant to be, initially allowing the defendant to be released from custody. The Commonwealth demonstrated itself capable in that context, given a week or two, to put a witness on the stand to submit sworn affidavits in favor of its position. After the Commonwealth put the special sheriff on the stand at the January 19th hearing, this judge, Justice Wilkins, issued a decision saying the conditions at Billerica are much better than at South Bay. The defendant is in a better position now than it appears he was in the fall when I denied both of his motions. So we get that ruling. 2.5 weeks later, with no prior notice, the defendant just files another motion, completely self-serving, no time for the Commonwealth to respond, no evidentiary hearing, no non-evidentiary hearing, and the judge says, now I believe everything the defendant's saying, this is an abject failure by the Commonwealth, this man must be released.
So
I mean, I
to
can't
put-
imagine a bigger abuse of
not
discretion
to
than
put
that.
words in your mouth, but you would say, I think what you're saying is that this is an error of law, abuse of discretion, and the open issue in Comiso doesn't have to be reached in this case.
I don't think you have to reach it. I mean, certainly the judge,
Because
it's awkward because the judge did conduct de novo review, and his ruling is a ruling based on de novo review. But the Commonwealth has always maintained, both before the single justice and in its brief before this court, that alternatively you can easily find that this was an abuse of discretion or error of law. And, you know, even if this court feels like the appropriate course of action was to remand this to the trial judge to hold a hearing, the evidence would have still come in the same way. And another thing I think is important to note, Justice George gave the defendant every opportunity to call his own witnesses. He indicated that he would hold we scheduled the hearing for 1 week from the initial February 5th preliminary hearing. He told the defendant that he would take evidence, and the Commonwealth said it would make itself available to take evidence from the defendant's witnesses, any of his medical providers, on any day of the following week to accommodate their schedules. The defendant indicated that preliminary hearing that she wanted them to be heard because the Commonwealth's position had consistently been, we're not saying this doctor isn't qualified, but these are just unsworn letters taking everything the defendant says at face value without any opportunity for the Commonwealth to test it. He still didn't call anybody, so all the single justice was left with was the Commonwealth's witnesses, who amply established not only that they're caring for the defendant properly and sufficiently, but that all MGH had to do was pick up the phone and call the facility and say, anytime this guy complains of an AFib episode, take him to MGH. And they said, that would be very awkward for us to do, but we would do it if MGH told us to do it, but they've never called us, they've never dictated that that's the level of care this defendant needs. So I think it exacerbates the unfairness to the Commonwealth that instead of working with the House of Correction and working with the individuals in the specialized medical unit that are willing to alter his care to the degree necessary to ensure that he is not facing a severe risk of harm, his medical professionals elect not to do that and instead to just repeatedly petition the court to release him from custody.
Mr. Charles, let me ask you, are you done with Justice Hoey's answer? Are you done answering this question?
Yes.
Okay.
Thank you.
Let me ask you about the first issue Ms. Jerusalem raised, that is, whether the Commonwealth has a right to 211(3) in every bail denial. Where do we draw the line? What's the legal standard?
So again, I think, as I said, as I indicated to Justice Lowy before, I don't think this needs to be sort of a global case. I think
Okay,
here
I get that. Answer my question. Where do we draw the line? What's the legal standard? Because we can't keep doing this, right?
just
So
to
then the
clarify,
next case will come up and we'll say, well, we don't have to reach it and we have no standard. So give me a standard.
so I'm not sure, first I just want to say, I'm not sure the court needs a limiting standard because I think Ray and Luigi, among other cases, which the Commonwealth cited in its brief, demonstrate that the Commonwealth has a right to appeal adverse bail decisions, at a minimum when there's an error of law. And here, again, the Commonwealth claims that that's the case. But still, I don't think there's a limiting principle necessary because while my sister makes this sky is falling argument, in most cases, the presumption in favor of bail will apply. And I think, given the fact that this court is not inundated with appeals where the single justice reverses bail decision in favor of the defendant, I think that's sort of indicative of the fact that even when they do make their way up to the single justice, they're largely getting rejected because there is a presumption in favor of bail, and normally they're just resolved on an abuse of discretion standard. I think this case is very specific to its facts, and I don't really see any reason for the court to go any further with it. But I stand by the fact that there is clear authority that authorizes the Commonwealth to take bail reviews to this court's single justice, or to the county court's single justice, and there's no contrary case law saying it can't. So, and I see no reason to blaze a new trail here where we clearly have a record that supports the Commonwealth's position, whether you want to consider it under de novo or abuse of discretion. And, the other thing I would just like to note is that my sister suggests, I think alternatively in her brief, that this might be a situation where the defendant has just been held so long that there's due process implications. But I just want to make the record clear. The reason this defendant hasn't been tried yet lays entirely at his feet. This defendant filed, I want to say, 8 motions to suppress. He's filed a McCarthy motion to dismiss, an Odell motion to dismiss. He has a pending motion to reconsider a previously denied motion to suppress. The Commonwealth has been ready for trial and discovery has been complete for a very long time. This defendant filed 3 motions to continue pre-COVID in the months leading up to it, on September 25th of 2019, on December 10th of 2019, and then again post-COVID on August 5th of this year, to move his trial. The defendant's motions. The Commonwealth has been ready and willing to try this case. The co-defendants' motions have exhausted themselves. So I don't want to belittle anything, and I understand that COVID creates a changed circumstance, but I think that has to be considered too. The Commonwealth was ready pre-COVID to try this case. The reason this case has dragged on and the reason the defendant's facing all of these impediments is because he's not ready to try the case. So I don't think it's fair to hold that against the Commonwealth. And if there are no further questions.
I do have one last question. If there is a 211-3 petition and there is an abuse of discretion by the trial judge, but the single justice reviews the matter de novo, you're not aware of anything that precludes the full court from reviewing the determination of the Superior Court judge for error of law or abuse of discretion, are you?
That's an interesting question. Off the top of my head, I'm not, Your Honor. I apologize. I'll certainly be happy to search for that case if it exists and submit it in a post-argument letter if I find it. But if there are no further questions, the Commonwealth would ask that you either affirm the single justice's ruling either under the de novo standard or find that there was an error of law or abuse of discretion by the Superior Court judge and that this defendant should not be released. Thank you.
Okay, thank you.